Now, last week, the Attorney-General accused this program of misleading the public over aspects of the Henry Keogh case, mainly regarding the insurance evidence. While never taking a position on guilt or innocence, we have raised concerns that there cannot be a fair trial when crucial facts are withheld from the court, most particularly if the case, like Keogh's, is circumstantial. So tonight, we re-examine what facts exist on the insurance policies and, in the spirit of full disclosure, reveal for the first time information we've had for 6 years showing the prosecution did withhold sensitive medical evidence from the court. Graham Archer has the details.
You have obscured deliberately from the public of South Australia the evidence regarding the insurance policies. For the past few years, you have refused to run on your program that Henry Keogh falsified and admitted falsifying the signature of the deceased on life insurance policies running to millions of dollars.
Simply not true, but we have focused on the flawed forensic evidence in the Henry Keogh case for obvious reasons. Such things undermine our system of justice. But now there's more.
Just hang on.
Yeah, of course.
And quite rightly, we've reported things as they've progressed, but hold that thought. So we can never be accused of ignoring it, let's look again at the insurance evidence and some new evidence that's never been revealed. The prosecution case was that Henry Keogh cooked up a scheme taking out 5 insurance policies totalling $1.2 million, that Keogh secretly signed Anna Jane Chaney's name on the policies and the cheques paying the premiums, and then 12 months later murdered her for the proceeds. The first jury was not persuaded.
After 10 hours of deliberation, the decision ended in deadlock, the jury unable to deliver a verdict.
And the second jury was persuaded. Of course, it was just a theory, as the evidence was entirely circumstantial. So what were the facts as far as we know them? In 1992, Keogh and Anna Jane worked for the State Bank, which had just lost $4 billion and was on the brink of collapse.
One of the first worries, the likelihood of big job losses, with the Bank Employees Union predicting 500 staff will be axed.
As a lawyer, Anna could easily find other work, but not so easy for Keogh, who as a fallback set up agencies with 5 insurance companies. These agencies would lapse if insurance wasn't written for each one on a regular basis, and it was a common practice to write more or less bogus policies to keep agencies alive. Keogh signed up a number of policies for genuine customers, some others covering his own life, as well as the 5 in question, 2 covering both Anna and himself, and 3 on just Anna's life alone. The premiums for the 5 policies came out of a joint account which Anna helped Keogh set up and to which she had full access. After her death, Keogh volunteered the fact that he'd signed her name on all 5 policies. Initially, he said no comment to police on legal advice. He claimed he feared a charge of insurance fraud. The prosecution claimed it was to hide his guilt. The DPP confirmed in court that
the deceased knew some of the insurance, but not all.
This meant that Anna knew he'd signed her name on at least some of the policies and obviously approved. Some media quite wrongly reported all the policies were a total secret. This is still what many people believe. Keogh's ex-wife, Sue, gave evidence that it was normal for him to sign her name on insurance and other financial documents.
Well, while we were married, as a matter of convenience, Henry always signed papers for me, and he had my permission to do that, and I had no problem with that. It was just a matter of convenience.
There is documented evidence that Anna, in fact, knew about all 5 policies. Their weekly premiums totalled $36, the exact amount Anna put down as her weekly life insurance expenses in 2 bank loan applications she made in November 93 and March 94. The DPP argued this $36 represented her mutual hospital and income protection payments, when in fact both had been cancelled months before the loan applications were made. Anna's brother Mark gave evidence that in a discussion about wills, she'd told him she had $400,000 worth of life insurance.
She told me she had some insurance and the amount was $400,000.
Keogh told police only 2 of the 5 policies were genuine, the 2 covering injury and death for both of them. These added up to $400,000, precisely the amount Anna had mentioned to her brother. When the Cheney family later claimed the insurance for themselves, it was only those genuine policies they could claim on, that is $400,000. The family's statement of claim states,
Cheney advised her mother, father and brother that she had life insurance cover for $400,000. By implication, the policies were valid and enforceable and arranged by Keogh in good faith.
It's exactly as Keogh had described things, and the family received the 6-figure payout. Keogh had handed over the policies to the police voluntarily days after Anna's death. The first folder contained the so-called non-genuine policies, and a day or 2 later he found the second folder containing the genuine policies worth $400,000. Keogh's lawyer wrote to the insurance companies to notify them of Anna's death on receipt of the genuine policies. It would have been negligent of a lawyer to do otherwise. Keogh continued to pay the premiums by direct debit after Anna's death. This action was viewed as a sign of guilt, but it hardly mattered one way or another. If in the first few days after the death of his fiancée he had denied there was a will, in handing up the policies he was still revealing the fact that he was the beneficiary. Last week the Attorney-General was prepared to mislead the media and the public by claiming
life insurance policies running to millions of dollars.
Again, that was
life insurance policies running to millions of dollars.
The AG knew this was untrue. It was never millions. In fact, at most, it was $400,000, which at the very least makes murder a less attractive proposition. Evidence was given that Keogh had affairs with 2 women. He was presented as a cad who'd betrayed his loyal fiancée. This again dominated the media coverage and forever influenced the public's view of the case. However, we can now reveal that the forensic evidence was not the only evidence withheld from the juries and the defence.
We're aware of her previous medical history and that was made available to defence.
This statement by the DPP is not correct. Anna's medical records were not released to the defence, and now, if you want further proof, here it is. Today Tonight have known for years Anna Jane Cheney had a pregnancy test prior to her death. To her relief, it was negative. And why? Because it could not have involved Henry Keogh. Keogh had had a vasectomy years earlier. He could not have been the father. So it would appear Anna Jane had secrets of her own, and they were allowed to remain just that.
Of their own health.
When we raised the issue of her medical state with the DPP 6 years ago, it became clear he and his legal associate off camera were well aware evidence had been withheld.
Yes, and for us to explain that is yet another thing that her family have to deal with. So inappropriate.
No such consideration for Henry Keogh's family. There is other evidence, of course, from both sides, none of which absolutely answers the question of whether Keogh did or did not murder his fiancée. All the more important that the jury was given all the facts. Sadly, we have a chief law officer who applies the rules selectively himself. Last week, his lips were sealed from discussing the unprofessional conduct finding against pathologist Dr. Ross James because he'd appealed.
But it would be highly inappropriate for me to canvass a decision which is subject to appeal.
And yet yesterday in Parliament, the AG came out barracking for Dr. James in the face of pertinent questions from the opposition leader Martin Hamilton-Smith.
Dr. James is very highly regarded throughout the legal profession, and I note my colleague, the pathologist, the member for Adelaide, interjects here. That's right.
Isn't it great to have friends in high places? Dr. James' expertise is all the more reason that there's no excuse for his conduct. But enough said, except to remind the Attorney-General of the one thing he said which did make sense. But the key thing here is that two senior forensic pathologists misinformed juries in this state. Is that okay by you?
No, it isn't.
Graham Archer there, and when we come back, Australia's brightest new ideas, our young inventors and their clever creations.